La siguiente mesa en nuestro programa se titula Experiencia Internacional en el tema desde las Autoridades de Competencia. Nos acompaña para exponer Tobías Mas, coordinador de casos antimonopolio en el Directorado General de Competencia de la Unión Europea; Mark Hegedus, abogado litigante de la Comisión Federal de Comercio de los Estados Unidos de América; Jonathan Shapland, consejero jurídico del Buró de Competencia de Canadá; John McKeans, director jurídico en la Autoridad de Competencia del Reino Unido; y Víctor Santelices, jefe de la División de Litigios en la Fiscalía Nacional Económica de Chile. Modera la mesa Sergio López Rodríguez, titular de la Autoridad Investigadora, la Comisión Federal de Competencia Económica.
Bueno, muy buenos días a todos. Gracias, Víctor, por la introducción de los panelistas. En esta mesa, que sin duda será de gran interés para todos ustedes, tendremos la oportunidad de conocer el punto de vista respecto a la aplicación del privilegio legal en 5 jurisdicciones. Como ya comentó Víctor Madrid, tenemos presente gente de la Unión Europea, de la Federal Trade Commission de los Estados Unidos de América, de Canadá, de Chile y del Reino Unido. Para facilitar la interacción con los ponentes durante esta sesión, realizaremos la discusión en inglés, de manera que sea más práctica e interactiva, por lo que procederé de esta manera a partir de este momento. The session will be divided in 2 sections. The first one will focus on the application of the legal privilege in each of the jurisdictions. And in the second section, speakers will resolve on practical questions on the matter. So, to make the best of the time we have, since we have a really tight agenda, let me open the table for discussion. The first subject we'll be on is the scope legal privilege has in different jurisdictions. John, why don't you explain what is considered legal advice privilege in the United Kingdom and which documents or communications can be considered privileged?
A number of the speakers have already mentioned that the concept of legal privilege is very well established in common law jurisdictions like the UK. However, despite having existed for several hundred years, the law in this area is still evolving and is quite complex. So I wouldn't worry too much if you don't get answers to all the questions today. There are still a number of questions in UK law that remain unclear even today. In the UK, there are 2 main types of legal privilege: legal advice privilege and litigation privilege. I'm just going to talk about legal advice privilege, but I think Jonathan's going to say a few words about litigation privilege a little later on. In order to be covered by legal advice privilege, there needs to be a confidential communication between a lawyer and a client, which was created with the purpose of obtaining or giving or receiving legal advice in a relevant legal context. So I'll take each of those in turn just to explain the scope of the principle. So firstly, a confidential communication. If a document is disclosed in circumstances where it's no longer confidential, then privilege will be lost. So it's only confidential material that is privileged. A communication includes both oral and written communications, and what matters in this context is the substance of what's being said rather than the form. So, for example, a summary of legal advice given by a lawyer will still be privileged. What do we mean by a lawyer in the UK? Well, the concept's been interpreted quite broadly and more broadly than in other jurisdictions, and particularly in the EU. So essentially, privilege applies where there is a qualified lawyer or someone working under the supervision of a qualified lawyer. So, for example, administrative staff or trainees would be covered if they're supervised by a qualified lawyer. By qualified lawyer, we include within that foreign lawyers, so not just people qualified in the UK, but qualified in any jurisdiction, and we also include in-house lawyers. The concept of client is one area where the law has been evolving in recent years. So historically, it was assumed that where a company obtained legal advice, any communication between employees of that company and the lawyer would be privileged. But there has been a number of cases in recent years which have narrowed the definition of legal privilege in this area. So it's only those employees of a company who are tasked with authorized to obtain legal advice. It's only those communications which are privileged. So, for example, if a lawyer speaks to employees of a company with a view to obtaining evidence about what's happened, if it's not those employees that are instructing the lawyer, that communication will not necessarily be privileged. And that's quite important in a competition context, for example. So where a company gathers information as part of an internal investigation, some of those discussions may not be privileged, even though it's the lawyer gathering the information. Finally, the communication, in order to be privileged, must have been created for the purposes of obtaining legal advice and be given in a relevant legal context. So this is a particular issue where, for example, with in-house lawyers that maybe have dual functions, so it's only where they're exercising their function as a professional legal advisor that the communication will be privileged. So if they're giving commercial advice, then that wouldn't be covered. But the concept of legal advice is defined relatively broadly. So, for example, there's been case law which says that comments on the presentation of a document, if given in the overall context of giving legal advice, are still covered by privilege. And likewise, where there's a chain of communications between a lawyer and a client, even if a particular email doesn't set out the lawyer's legal advice, if it's part of a context of obtaining legal advice, then the whole chain will be confidential.
Thank you, John. Now, Mark, please explain the U.S. approach to these issues, and if possible, help us identify the main contrast to the UK approach.
Thank you very much, and very much appreciate having the opportunity to talk about this. In general terms, the approach in the United States is very similar to the UK approach. Also, though, what is striking is despite the age of the privilege, the fact that there are still key issues that remain to be addressed clearly by the courts are outstanding. For example, this issue of whether or not a document is for the purpose of legal advice or business advice. What do you do in the situation where you have a document that addresses both kinds of matters? We have some differences amongst our courts of appeals, our federal courts of appeals, in terms of whether or not it should be a predominant purpose of the document or whether the document can be protected only if it has a purpose, but only one purpose among others, providing legal advice. Similarly, we see an issue with trying to determine when is a lawyer, particularly an in-house counsel, acting as a lawyer or acting as a business person. And it can be quite tricky in the context of, say, you have a senior vice president within a company who's helping to negotiate a merger. And there are times when those negotiations will be involving the business terms of the merger. But there may be other times when the discussions will turn to whether or not this particular transaction can be justified to competition authorities. And so we don't yet have clear guidance from our courts exactly where you draw those lines. Presently, my agency, the Federal Trade Commission, is litigating a case before the U.S. Court of Appeals for the District of Columbia Circuit, addressing this very issue. And even though the argument was back in November, we don't yet have a decision, which may suggest the difficulty of trying to come up with the lines to draw here. The one other thing I will note is that with respect to this differentiation between legal advice privilege and litigation privilege, the litigation privilege, as we conceive of it in the United States, we think of it more or less a privilege, and it comes under the rubric of a work product doctrine. And I'll cover in a little bit why that distinction between privilege and versus a work product doctrine is important in terms of some of the practicalities of applying the work product doctrine as opposed to the privilege.
Thank you, Mark. Tobias, what about the application of a privilege in the EU? Is the application more lenient or broader? And does it apply to communications with all lawyers within the EU?
Thank you, Sergio. And let me first say also thank you for the invitation to speak here, to the chairwoman from COFSE for the invitation. For you for organizing this panel so good, and Carolina for the overall organization, and maybe also to the translators who do an excellent job, so I was able to follow them Thank you. I hope I don't speak too fast, but we don't have so much time, so I apologize already to them. With that said, also a little disclaimer. I'm always forced when I speak to say, of course, that I speak in my own capacity, and it does not necessarily reflect the opinion of the EU Commission or the European Union, but I hope it does. So, getting to the topic. Are we more lenient or more broader? I think that we might be currently seen, at least on the rules, more restrict. That comes that our main principles were developed by the European courts in 3 judgments. They took into account how it is regulated in our member states, but they did not see that it needs to be identical in scope. And we don't have it codified as hard law. We have some soft law, we have best practices in antitrust, and we're currently reflecting on best practices in mergers on that topic because it got more and more relevant on it. And I agree here with John and Mark that the area is still developing. I think it's impossible to put all the different nuances and variations in a legal text. So I think it's good to focus just on the principles and a kind of procedure how to solve these things. So what is the scope? A little bit similar as it says. It's normally a communication between an EU independent lawyer made for the purpose and in the interest of the exercise of the client's rights of defense. That protection also extends then to earlier written communication between the lawyer and client, which have a relationship to the subject matter of that procedure. So also earlier before we even open proceedings. Internal notes, as also here it was mentioned, who kind of are confined in summarizing these communications are also protected. And we also protect preparatory documents which are prepared exclusively for the purpose of seeking advice, even if this document itself is never communicated to the external lawyer. Let me probably say where we are a little bit more stricter than our colleagues more also from the Anglo-American sphere is that similar here to Mexico, we don't recognize the privilege for in-house counsel as they were not seen by the court as sufficiently independent and because of their economic links to the company. So they were explicitly excluded from the scope. But however, if they prepare exclusively a document, exclusively for the purpose of seeking advice with the external lawyer, that would be again protected. And we think this system works quite fine, so that we cannot report that compliance departments would shrink after that judgment. No, we see that European companies invest heavily in compliance departments within their companies. So it seems to work. Maybe another different to these preparatory documents is that sometimes it's changed with pre-existing documents which are then sent to the lawyer. These are normally not protected. So a document which was created for a different purpose doesn't get just the protection because I send it to the lawyer.
Well, thank you to the UK, USA, and EU for these interventions related to the scope of the legal privilege. And let's talk about who holds the right of the privileged information. Victor, could you start by explaining how does Fiscalía act with this?
Gracias, Sergio. En primer lugar, agradecer a COFESI y también al Instituto de Investigaciones Jurídicas de la Universidad por la invitación y la oportunidad de compartir esta mesa de discusión. en atención a transmitir adecuadamente las ideas y con precisión que, digamos, voy a exponer, me he tomado la libertad, anunciando a Sergio, de hacer mi exposición en español. Y la primera idea que quiero transmitir a este respecto es que, principalmente escuchando el panel anterior respecto de la situación existente en México, en Chile nos encontramos frente a una realidad bastante similar en cuanto a la ausencia de una regulación exhaustiva, y como autoridad de competencia lo que tenemos que hacer es precisamente lidiar con ello para efectos de garantizar estos derechos que provienen desde el marco constitucional. Entonces, en tal sentido, a la primera pregunta de Sergio, ¿quién tiene este derecho? Lo cierto es que parece bastante intuitivo, si bien la ley así no lo establece, al menos en el caso de Chile, expresamente, que este derecho le asiste al cliente. Y le asiste al cliente básicamente porque está vinculado a regulación respecto a las investigaciones penales, en que la posición del imputado o de la persona investigada por estas infracciones de carácter penal es esencial respecto a la debido respeto de las garantías que llevan este procedimiento. Sin embargo, la regulación misma que se hace al respecto en la ley dice relación con las personas a las cuales le asiste este privilegio, es decir, enfocando ya no en el cliente, sino más bien precisamente en la persona que puede reclamar. Y la regulación, analizando lo que veíamos en el panel anterior, es bastante similar a las personas que por su estado o profesión tienen el derecho a guardar secreto, como el médico, el abogado, el confesor. Lo cierto es que a partir de la formulación de que esas personas tienen derecho a no declarar, es también la regulación que se establece respecto al respeto de este deber de confidencialidad por parte de la autoridad en el marco de sus atribuciones. Y básicamente, sin querer extenderme en exceso, en la Fiscalía nos encontramos enfrentados a este procedimiento en dos ámbitos. En el primer ámbito, mediante la solicitud de información, de antecedentes en el marco de nuestras propias investigaciones, que implican una colaboración voluntaria por parte de los agentes investigados. Nosotros entendemos que si el agente investigado aporta información en el sentido que pudiera considerarse contenida dentro del privilegio, ha habido una renuncia expresa respecto a ese derecho, y esa es una realidad para nosotros. Ya, efectivamente, todos nuestros investigados, todos los agentes económicos están debidamente asesorados y tienen esa posibilidad. Y la segunda, donde sí hay una diferencia respecto a la realidad mexicana bastante más evidente, es en el ejercicio de facultades intrusivas. Esto es mediante la autorización que, en nuestro caso, para hacerla efectiva respecto de interceptaciones telefónicas o de medidas de entrada de registro e incautación de evidencia, necesitamos una autorización previa judicial. Y esa autorización enmarca la posibilidad de ejecutar este tipo de diligencias. Ahora, ¿qué sucede si efectivamente se incautan o se obtienen comunicaciones respecto de que están contenidas dentro del privilegio? La posibilidad de perder toda la evidencia incautada es demasiado alta, porque existe un mecanismo de impugnación claro ante el mismo juez que otorgó esa medida para efectos de que el defendido pueda excluir esa evidencia del conocimiento del tribunal. En nuestro caso, el procedimiento investigativo se agota en la Fiscalía, pero después ese juicio se defiende ante un tribunal independiente, por lo tanto el riesgo es demasiado evidente en ese caso. Y un aspecto que es muy relevante y que no está definitivamente tratado, digamos, en nuestra legislación, es lo que sucede respecto a los informes de carácter económico. En el ámbito de libre competencia, evidentemente la naturaleza económica de muchos informes hace que estos puedan estar estrictamente vinculados con la defensa de un investigado. Sin embargo, como les mencioné, la legislación no incorpora al economista, y esa es la realidad hoy. Por lo tanto, lo que tendremos que hacer, viéndonos expuestos a esas circunstancias, es tratar de defender que no se encuentra amparado por un privilegio establecido en la ley. Y solamente, dado que no tenemos, a diferencia de lo que exponía Marc, una teoría desarrollada respecto del privilegio en el ámbito de litigación, tratar de sostener la validez de esa evidencia luego de llevada en juicio.
Thank you, Victor. That's really, really interesting. How do you approach this topic in Chile? John, maybe you can describe how the right is protected in the UK.
Thank you. So similar to Chile, the privilege belongs to the client, so only the client can choose whether to waive privilege. But a lawyer has a professional obligation to respect the client's privilege, so that the lawyer needs to do what the client says, effectively. We also have a concept of joint privilege in the UK. So, for example, if a lawyer is instructed by several clients in relation to the same issue, or several parties, the advice is obtained for the benefit of more than one party, then that can be subject to what's called joint privilege, which means the privilege is held by all the parties together, and one single client can't unilaterally decide to waive privilege. So this, a practical example of how this affects our work in practice. I was recently working on a case involving a joint venture where the parent companies to the joint venture were alleged to have behaved anti-competitively, and one of the parents voluntarily disclosed some of the legal advice that they'd received, the other party found out about that and then claimed joint interest privilege. So we ended up having to return the documents because the party couldn't unilaterally decide to disclose the privilege. So sometimes it can be a bit more complicated where there are multiple parties involved.
Thank you. Thank you, John. Now, Jonathan, are there any difference with the Canadian application of privilege to the ones John and Victor have just discussed?
Muchas gracias para invitarme aquí. Yo voy a hablar principalmente en inglés porque es más fácil para mí y probablemente es más fácil para ustedes de comprenderme. Tal vez a veces yo voy a hablar en español. I'll also give the same disclaimer that if I'm providing opinions, those are my opinions. They may not be the same as the Department of Justice of Canada or the Competition Bureau or the public prosecutors in Canada. So what I'd like to start is we've been talking about privileges, and really what we've been talking about in terms of Canada are called class privileges. In other words, privileges, if it falls into that area, those are privileged documents, as opposed to what we also have of case-by-case privileges where you have to look at each document. So if it's solicitor-client, it's a class privilege. You don't have to look at that document to determine if that specific document is privileged. And there's 4 types of class privileges that we have in Canada. Solicitor-client privilege, which we've been talking about all day. Litigation privilege, which I'll be talking about a little more and has been referred to. And then there's also informer privilege and settlement privilege. Until very recently, there was also a public interest privilege that we had in Canada for 28 years for the Competition Bureau, where if the Competition Bureau got information from third parties, those were also assumed to be privileged. The Federal Court of Appeal decided that that did not fall within one of the privileges that the Supreme Court of Canada had said there was only 4. So I argued that case before the Federal Court of Appeal and lost. So now it's a case-by-case privilege. In terms of differences, there aren't really a lot of differences from what you've heard from my colleagues. I can indicate that while solicitor-client privilege is a common law privilege, as you've heard from a number of speakers from the United States and as well John today, the Supreme Court of Canada has indicated that it has taken on over the years the aspect of a quasi-constitutional law, even though it's originally a common law principle. Supreme Court of Canada in one case, and this is echoing what Roger said without this privilege, clients could never be candid and furnish all the relevant information they must be provided to lawyers if they are to be properly advise their clients. It is an element that is both integral and is extremely important to the functioning of the legal system. It is because of this fundamental importance of the privilege that the onus properly rests upon those seeking to set aside the privilege and justify taking such a step. And we'll be talking about that later. The last thing I'd like to talk about at this juncture is, yes, as you've heard elsewhere here, it is the client's privilege, not the lawyer's privilege. And we heard, I was very interested to hear from some of the speakers earlier about the importance of the lawyer's duty and the Code of Professional Conduct in Mexico, or perhaps lack thereof in certain instances, in terms of enforcing that. And the codes of professional conduct in Canada are very clear, and I'm quoting here from the Federation of Law Society, a model code that the provinces, because the jurisdiction is provincial, have been followed. They say the rule is a lawyer at all times must hold in strict confidence all information concerning the business and affairs of a client acquired in the course of a professional relationship and must not divulge any information unless it was expressly or impliedly authorized by the client, required by a court to do so, required to deliver information to a law society, or otherwise permitted. And they go on to say that this rule is wider than the legal rule of solicitor-client privilege enforced by the courts. And so if there's a breach of this rule, a lawyer could be disciplined or ultimately disbarred. And I think that's a subject that it sounds like you need to, or you want to continue discussing in terms of the regulations of lawyers in Mexico.
Thank you, Jonathan. So those were the interpretations from Chile, UK, and Canada related to who holds the right of the privileged information. To discuss different concepts related to privileged information, Jonathan, why don't you continue by introducing the difference between solicitor-client privilege and litigation privilege?
So, la Corte dijeron que una proteger una relación y otra es para proteger un proceso. Yo voy a explicar. The solicitor-client privilege is to protect the relationship between the solicitor and client, as we talked about a moment ago, to allow the client to freely divulge to the solicitor all of the information necessary in order to get proper legal advice. Litigation privilege, on the other hand, is to protect the process, an adversarial process in the common law countries. And basically, the courts have talked about, the Supreme Court of Canada determined that it creates a zone of privacy so that when the client and the lawyer are preparing a case, they don't, in effect, have the other side looking over their shoulder. As we heard earlier, facts are not protected. Facts have to be divulged, but the process of and the communications are protected. So there's four differences that the court has referred to in terms of differences between solicitor-client privilege and litigation privilege. First of all, solicitor-client privilege is wider than solicitor-client privilege, and it can extend to communications of people beyond the solicitor and the client. So, for example, experts, the client talking to an expert without the lawyer there could also be covered by the litigation privilege. It's only in the context of litigation or anticipated litigation. In other words, if it's reasonable to assume that one is going to be sued, that would apply as well. But the predominant purpose has to be for the litigation. And, okay, I said that. The most important one, or one of the most important ones, is that the litigation privilege comes to an end when the litigation is over, unless there's related litigation. So there's no more reason to protect it, as opposed to solicitor-client privilege, which continues on indefinitely. But if the reason is to protect the privilege so that the other side can't see all your notes as to what you were saying to witnesses or ideas that had been thrown out early on in the litigation, there's no reason to protect that unless it's solicitor-client privilege. And obviously, there is an overlap where certain documents may very well be privileged by solicitor-client privilege and litigation privilege.
Thank you, Jonathan. Mark, I believe similar things happen in the U.S. Is that right?
That is correct. The United States. That is correct. The United States law does draw the distinction between the attorney-client privilege and the work product doctrine. I did want to comment just with respect to the class privileges in Canada. We don't have something quite so similar in the United States where ahead of time we've declared a certain body of documents or communications will be privileged. But as a practical matter, in the course of an investigation or, say, a litigation, the parties in working through the privilege issues can make a determination of, say, communications with your outside lawyers that happen after the filing of a suit. We shall determine that those are all privileged, and you will not have to list those on the log, the privilege log, which is the way by which parties assert the privilege in the United States. One issue that I think it's important to underscore with respect to the distinction between work product doctrine and the attorney-client privilege is the privilege is pretty much inviolate. It's a confidentiality that protects the client's information. In the United States, at least, work product is able to be obtained by the opposing side if a showing is made that the side requiring or seeking the information has a substantial need for that information, and it would be an undue burden upon the side to obtain that information. So, for example, suppose you're an attorney in the course of litigation, you interview a witness, you take notes, the witness later dies. And later on in the litigation, what that lawyer or what that witness says is important to your opposing side. That may create a circumstance where the opposing side can show a substantial need for obtaining that work product and undue burden in trying to obtain it. The burden there obviously is the witness is no longer available. Another important issue with respect to the work product doctrine is it draws a distinction between work product that we call fact work product, a compilation of facts, factual analyses, and those you are able to get discovery on them if you satisfy the substantial need requirement. By contrast, our courts classify work product as opinion work product, which is the attorney's mental processes, their mental impressions, their thoughts about the litigation strategy of the case. And that is almost never available to the other side. One of the reasons why I think it's important to think of work product as not a privilege necessarily is the fact that you are able to obtain it. You can also share it with third parties. Suppose, for example, you're working with an economist or an accountant, and it's information you've developed for your client. You can do some sharing with other parties without losing the protection of the work product doctrine. By contrast, with the privileged information, if you share confidential information with a third party and that third party is not otherwise in some kind of common interest with you, then you lose the protection of that privilege.
Well, thank you to Jonathan and Mark for their interventions related to the different types of privilege in their countries. On a different issue, it would be interesting to talk about those cases in which the privilege can be withdrawn or waived, or it is non-applicable. Tobias, would you like to begin?
Sure. So, of course, as all the other privileges you have to exercise your rights of defense, you can also waive them. The EU allows that you waive them for parts. You don't have to waive kind of the whole privilege, so you can waive it for some parts of the documents, but not waive it for other documents. You need to do the waiver needs to be in writing and explicit and defined in scope, because indeed we take the privilege very serious. So we don't want that a client is just waiving it, as we had also cases just for the future forever. I don't want to have it. So no, it needs to be very explicit in scope, in writing. We need to know which documents are covered. And maybe also to make clear, you don't just waive it by, for example, answering an information request and you send us documents. If you have not explicitly waived your rights on privilege, just sending us the documents, we don't see as an automatic waiver. The same is also in a dawn rate when the waiver is not made explicit. We have also, and we see that the document is very likely privileged. We have a duty to tell the client that there might be a privilege issue and to ask him if he is willing to explicitly waive that privilege. Of course, you could also waive your privilege, and we heard it before, by sending the advice you got to a third party. For example, that we also had cases where lawyer gave advice and then the party sent it to all the members of the cartel and say, look, this is what the lawyer told me what we should do. Of course, that was not any more privileged. Maybe one aspect I want to touch, which also Roger in the beginning mentioned with the conflict, what happens actually when you send or you send the document to us. Do you waive it then for other jurisdictions? We have the issue sometimes with the in-house lawyer privilege, which is from the US. And there, the normal working conditions is if we collect the documents then in a dawn rate and we don't recognize the privilege, we understand it's not waived then in the US, so they don't lose the privilege. And sometimes they ask us, please issue a decision to compel us to give you the document for not losing the privilege in other jurisdiction. And we regularly do that, and it seems to work fine.
Thank you, Tobias. Mark, I know that in the U.S. sometimes the privilege is not waived but lost. Could you talk about that?
Yes. One of the concerns with privilege is a party using it in a strategic way. Suppose, for example, a party decides to disclose previously confidential information to an investigator or in the context of a court case in order to gain strategic advantage, to establish a fact. But then there are other facts that were communicated to the lawyer, and the party tries not to reveal those communications. And so the law has developed a concept of what we call sword and shield, that if you use your privileged information as a sword in the course of the litigation, then we're not going to let you then use it as a shield to protect that information. So there's a sense of unfairness to the other side if you use privileged information in such a way. And so if you do that, you could end up losing the privilege. Similarly, if you have a case where your defense is the advice of your lawyer, that your lawyer provided all the justification for, say, the conduct, and if you put that lawyer's advice in issue in the case, then you may well lose the privilege in that situation. Another issue that arises with respect to waiver is the issue of inadvertent disclosure, and this issue has become very important in today's world because of the number of electronic documents that the companies that we investigate and that all of us deal with. And so what you have in the context of litigation and investigations is the production of many, many electronic documents that then also need to be reviewed for privilege. And that privilege review process is time-consuming and costly. There has been a recognition by the U.S. courts and by the U.S. Congress in terms of the rules that govern litigation in the U.S. courts that because there are so many documents that have to be reviewed, that sometimes documents that are privileged, communications that are privileged are going to slip through. And we don't want companies and lawyers to constantly be living in fear of having lost the privilege because some of these documents slipped through inadvertently. And so when you produce a document inadvertently now, you have the capability to identify that to the opposing side and ask for it back. We usually call that clawback. And the other side is generally obligated to return it unless they have some reason to believe that, in fact, your production of the document was not inadvertent. And if, in fact, it's decided that you lose the privilege on that document, it no longer serves as this broad subject matter waiver over every single subject touched upon in the communication. The requirement is just to release the number of documents necessary to make sense of the document that was inadvertently disclosed. And the last piece of this that I think is important to know is that lawyers in the United States, as a general matter, have ethical obligations when they come across a document that looks to be privileged. They have an obligation to contact the other side to bring it to their attention, to say, we've come across a document that we believe is privileged and you may have inadvertently produced it. Please clarify the situation for us. Now, if you do that, if you do follow through on your obligations to notify, the other side then has an obligation to fix the problem. And so a problem that we have particularly in investigations where you have productions of documents over time, you add them to, say, your document review base, and the party keeps coming back to you and saying, well, I inadvertently produced a document. Oh, here's another one I inadvertently produced. And meanwhile, you've fed all these documents into a database, and it's quite difficult to pull them out. And so the Federal Trade Commission's view is that you have an obligation to go and identify those inadvertently produced documents and claw them back, ask for them back in a relatively short period of time. You can't be repeatedly coming back to us and asking for those documents and interfering with our investigation.
Thank you both for these interventions on how the privilege is waived or even lost in the EU or the United States. Let's talk about the exceptions for the application of the privilege. Jonathan, what happens in Canada?
Thank you. So just before that, I just wanted to note that Tobias talked about the waiver of part of a document. En Canadá, renunciar una parte de un documento es muy peligroso porque es probablemente que otra parte tiene derecho a todo el documento y tal vez posiblemente todo el documento, pero tal vez otros documentos asociados con este documento. Entonces, es muy raro que una persona va a renunciar una parte del documento. But returning to your question, which is the exceptions, as I said earlier, the exceptions on solicitor-client privilege are very narrow because it's a complete and a very strong privilege. So there's three that I'll talk about. First is the threat on public safety. And the Supreme Court of Canada has set out three criteria for that particular one. The first one is there a clear risk to an identifiable person or group of persons. In other words, if your client in a criminal context says, I'm so mad, I'm going to kill somebody, probably doesn't qualify. If he says, I'm so mad because my wife betrayed me, I'm going to go and kill her, well, then you're in a very different situation. And that's there'd be an obligation there, providing these two other. Is there a risk of serious bodily harm or death? So not, I'm so mad at the credit card company, I think I may defraud them because they owe me money. Lots of people probably say that. Secondly, and then finally, is the danger imminent? In other words, not some vague threat that might happen sometime in the future, but there's a real danger that something may happen to somebody. So that shows how narrowly. The second one is called either innocence at stake or wrongful conviction. And the court has said that this privilege should only be infringed where there's a core issue going to the guilt of the accused or involved, and there's a genuine risk of a wrongful conviction. In other words, not this would be useful to me because I think my lawyer could help raise a reasonable doubt, but this is something that's more crucial. And then secondly, before the innocence at stake is even considered, the accused must establish that the information he's seeking is not available from any other source, or that he's not or she's not able to raise a reasonable doubt as to the guilt in another way. In other words, it's a last resort. And the third one is, and this has been referred to in some of the previous presentations, lawyer advice on crime, or sometimes it's called the crime fraud exception. It comes from an English case in 1884. And if you think about what solicitor-client privilege is in all of the countries we've heard, the first one is that it's legitimate legal advice, right? So if you're advising somebody how to do a crime, the courts have said, well, that's not legal advice. That's not within the scope of the lawyer to tell people how to do crimes. So you're already, if you look at it that way, beyond solicitor-client privilege because it's not proper legal advice. Or how they put it, it doesn't fall within the ordinary scope of a lawyer's employment. Because remember, the four criteria for solicitor-client privilege is that the client is seeking advice from a lawyer, the lawyer is providing advice in a professional capacity, the communication relates to legal advice, and the communication is in confidence. And I think we heard that basically from all the different countries. One would also note that this is clearly contrary to the rules of professional conduct, and the lawyer could be disbarred for such behavior.
Thank you, Jonathan. John, what about UK?
So I'll just say a few words about some differences regarding waiver. So in the UK, we don't have this idea of using privileged information as a sword or a shield, but we do have a concept of collateral waiver. So if you voluntarily choose to waive privilege over a particular document, in order to avoid kind of misleading the court, there's a rule that you can't cherry pick what you waive. So if in order to make sense of that document, there are other relevant documents that the court needs to see, then you're deemed to have waived privilege over those other documents. So the same would apply, for example, to waiver of part of a document. So if in order to make sense of the legal advice, you need to disclose the whole document, then you'd have to do that. The other point to make on inadvertent disclosure. So in the UK, we don't have... I think Tobias mentioned in the EU that they require waiver to be explicit. So there's no rule requiring waiver to be explicit in the UK. But in practice, and the courts have set out various guidance on when you can and can't rely on documents that have been disclosed inadvertently. So there's also no professional obligation that you can't rely on. In fact, as a general rule, the courts would say that if a lawyer receives documents that may be covered by privilege, they're entitled to assume that the party disclosing them has waived privilege over them. However, there are exceptions, in particular where it's an obvious mistake. So basically, if you choose to rely on privileged material, you do so at your own risk, and the court may disagree with you. So in practice, as an authority, and this is actually quite common for the reasons that Mark already outlined, that parties do inadvertently disclose privileged material quite frequently. So where we come across those sorts of documents, we tend to write to the parties and ask them to clarify whether they've chosen to waive privilege or not. Although, strictly speaking, we could possibly choose to rely on the document, we just choose not to as kind of risk management.
Thank you, John. Victor, how about Chile? And are there cases in which legal privilege does not apply in matters conducted by the Fiscalía?
Sí, bueno, un poco transversal a todas las exposiciones que hemos escuchado respecto de derecho comparado y también de lo que escuchamos acá en México. La única excepción contemplada en la ley chilena es precisamente la intervención del abogado en la conducta ilícita, y de nuevo se hace a propósito de la investigación de carácter penal, que por norma expresa es también aplicable en sede de competencia. En lo que me quiero detener en este aspecto es respecto al procedimiento, pensando un poco en las propuestas que el panel anterior nos ponía respecto a quién podía entrar a decidir o a revisar la existencia de esta excepción. Y lo cierto es que en el ámbito penal existe la posibilidad de que ante la solicitud de una medida de incautación en la cual se podría vulnerar el privilegio cliente-abogado, el juez está obligado, digamos, a fundar esa decisión en forma previa que ésta sea solicitada. lo cual nos lleva a un vacío regulatorio toda vez que probablemente si yo quiero incautar la oficina del abogado tengo indicios de que eso se puede producir, pero no regula el aspecto de qué sucede cuando en el marco de una incautación cualquiera, digamos, a la oficina del cliente, efectivamente encuentro este tipo de documentos. Y lo que señala la ley en estos casos es que precisamente no puede haber inspección alguna por parte ni del fiscal ni de la policía que está auxiliando, sino hasta que el juez que autorizó la diligencia efectúe lo que se denomina una revisión in cámara. Esto es, que ellos determinen que efectivamente se encuentra esa información amparada por el privilegio. De nuevo, lo que les quiero transmitir es que esto soluciona la posibilidad que yo puedo prever la existencia de una excepción al beneficio, pero no qué sucede en la práctica cuando esto se produce in situ, es decir, cuando en el marco de una diligencia en la cual yo no tenía previsto que pudiera producirse esta circunstancia, en los hechos se da. Adicionalmente a lo anterior, en el marco de libre competencia, ahora si bien es una norma aplicable, por la dinámica que se produce entre las autorizaciones escritas del ministro que autoriza esta diligencia, no se ha dado la práctica para efectos de establecer el tema. Y la segunda excepción, regulada ahora ya no a propósito de los mecanismos de incautación, sino que las escuchas telefónicas, hay una diferencia ahí sí sustancial entre la legislación penal y la aplicable en libre competencia. En la legislación penal se permite la interceptación de comunicaciones en el caso de las comunicaciones entre cliente y abogado para el mismo caso, es decir, la participación del abogado en la actuación criminal. En el caso de libre competencia, aun cuando a partir del año 2016 consideramos a la colusión como parte de un ilícito criminal, esto está absolutamente vedado. Es decir, en ningún caso se puede autorizar por parte del ministro respectivo la intervención de comunicaciones entre el abogado y el cliente.
Thank you, Victor. Those were the interventions from the UK and Chile on the exceptions for the application of the privilege. And I really appreciate all of your interventions and for respecting the time that was assigned. I know that all this intervention will be really useful for us since we are working on the legal framework on how to deal with this attorney-client privilege here in Mexico. I will now ask several specific questions about the procedural aspects on the application of legal privilege. Tobias, could you tell us what happens in such cases when physical and electronic information collected in done rates is subject to attorney-client privilege?
Sure. So, I mean, first, practically, when we do a dawn rate, mostly it's electronically. We collect the documents. They are partly scanned over hard disk. We have them on our laptop. And we're then often shadowed by lawyers who can sit next to the inspectors when they go through the document. The lawyers can also already beforehand say, we know of certain very specific documents, and then these can be taken out of it and treated separately. But if doing this shadowing, either the inspector himself or the lawyer notice that there might be a privilege, then normally, of course, the inspector stops looking at it. He should not look at the document or the content at it. And then it's practically discussed with the team leader. Sometimes the lawyer allows a cursorial look just to see who are the addressee, who is the sender, what's kind of the context. And if that is then qualified, this document is deleted out of this electronic file. And so that even when we don't take a bulk of documents, we normally, in these electronic searches, we identify the documents and we give the lawyers then a chance to look again through all the documents and indicate what are privileged. And then it will be discussed with our team leader and they will be taken out of it, deleted from the file. And even later on, even if we have taken the file in this dawn rate and it was not signaled by the lawyer or by the client that this is privileged and they tell us about it, we will later delete it out of our electronic file. So also our administrative file is purely electronic, and then we'll just write a letter back and reply that we accept that claim and we delete it from the file.
Thank you. John, what happens in the UK?
In the UK, it's fairly similar. There's probably a distinction between hard copy documents and electronic documents. So during an inspection, the party may claim that we shouldn't be looking at certain hard copy documents on the grounds of privilege, so we'd require them to explain why. And if we weren't satisfied with that explanation, then what typically we'd do is take the documents away in a sealed bag, and at a later date, we'd get an independent lawyer not working for the party or for the CMA to review the documents. And the same if we come across documents while we're searching where we suspect they may be privileged, then we stop looking at it and we put it in a blue bag and we take it away, and someone will look at it in due course. For electronic documents, it's slightly different. Our procedure nowadays, given the volume of electronic material that we typically collect, what we tend to do, rather than looking at it on site, is to take a copy of the server or part of the server and to put that in a sealed bag and to take that away. And then that's then processed by our forensic IT consultants who work for the CMA. And in order to ensure that we don't review potentially privileged material, what typically happens is that we agree a set of keyword search terms that we apply to the electronic material before reviewing it, typically the names of lawyers who've been advising the client during the relevant period. And that material is then filtered out from what we review. And that will either be reviewed by the party's lawyers, and they'll determine what is privileged, or we'll farm it out again to an independent lawyer to do that. So all the processes are basically designed to prevent the people on the team reviewing the privileged material. So it's either reviewed by an independent lawyer, or we have this kind of process with electronic material to filter out material that's likely to be privileged.
Thank you. Now, Mark, when the FTC issues information requests demanding information that may be subject to the privilege, what is the applicable procedure?
So in responding to subpoenas or civil investigative demands, the party producing the documents would have the opportunity to review their own documents for privilege. There are some examples, not dawn raids such as they exist in Europe, but in the United States, where both the Antitrust Division and the Federal Trade Commission may take possession of a party's documents without notice to that party to give them the opportunity to review those documents. And in the Federal Trade Commission context, we call that immediate access, and we tend to use those more in our investigation on the consumer protection side of the Federal Trade Commission Act. In the Antitrust Division context, it arises where in criminal enforcement matters, there's an execution of a search warrant. I bring those up because it highlights an important part of the procedure for reviewing documents that are seized from another party, and that's the involvement of a court reviewing the procedures to ensure that the parties who's producing or whose documents have been seized, the party's interest is protected. And so the review process is quite similar to what's been described here, but I think the fact that we have involvement of the U.S. court system to help provide a safety net for the parties whose documents are seized is an important aspect of the U.S. process.
Thank you. Jonathan, what is the procedure used by the Canadian authority?
So again, it's very similar to what's been described, and I brought a section of a court order, a warrant, that the Competition Bureau obtained, and I'll read you one paragraph because it follows exactly from what Mark was talking about. It says, "It is further ordered that when a claim is made that a record about to be examined, copied, or seized is subject to solicitor-client privilege, or when a person, blah, 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 has reason to believe that a record may be subject to solicitor-client privilege, unless the authorized representative of the commissioner desists from examining or copying the record must be placed in a package suitably sealed, placed in the custody of a person named in Section 19 of the Act." And 19 of the Competition Act essentially is a process to say where there is a claim of solicitor-client privilege in a document search, for example, then those questions go before a judge to determine. In practice, as John said, those are often worked out by an independent lawyer who doesn't work for the Competition Bureau. There was a situation I heard of recently where a criminal lawyer was involved in representing a company on a search, and the lawyer said, everything's privileged. Everything in this company is solicitor-client privileged. So the lawyer acting for us said, fine, we'll put this all before a judge. If you're claiming it, but please give us in writing that you're claiming it. We'll seal it all now. The claim never came.
Yeah. Really interesting. Once again, Mark, let me ask you, is there an area within the FTC that determines which information is privileged?
So the determination of privilege is ongoing through an investigation and then later on in litigation. When it's at the investigation stage, it is the investigative staff who will receive claims of privilege from the party producing documents, and then there will be an exchange of views with the party producing the documents if the FTC staff disagrees with the claim. Usually that takes place in writing, citing to case law and examples, and in the hope that you can convince the other side to your position. In some extreme cases, if the FTC has identified a document that they feel that they must have, and the party is withholding it on the basis of privilege, we have the ability to go into our federal court and seek to enforce a subpoena. And then the federal court will decide whether or not the document is privileged. When you get to that point, the problem from an investigation standpoint is that it really slows down the investigation because you can't rely upon a federal court acting quickly. Some pressure, though, we have with respect to the party being investigated is the investigation may have been confidential, non-public, but if we have to go in court to enforce our subpoena to get the document, the investigation is now public. So that is an incentive for the party to possibly cooperate with us in producing the document. When you are in litigation, we've actually filed the case. Then you have a judge or a magistrate judge who will be deciding privilege disputes. There's a lot of pressure in the U.S. court system for parties to work out the disputes on their own. Judges hate privilege disputes. They really think parties should be able to come to agreement on their own. But there are times, particularly I think when there's maybe some lack of clarity in the law, where the judge will just have to decide.
Thank you, Mark. Victor, how is this information dealt with by the Fiscalía?
Suspiro porque estamos en problemas nosotros respecto a ese tema, me doy cuenta. Sí, la ausencia regulatoria que tenemos hace que sea la práctica la que nos ha dado las indicaciones de cómo proceder. Yo escucho a Jonathan, a John respecto de los protocolos de actuación y lo cierto es que estamos lejos de ese tipo de práctica. En tal sentido, bueno, no tenemos, como mencioné, el problema cuando esos aportes son voluntarios respecto de los investigados, pero sí nos enfrentamos al problema frente a la incautación que se realiza autorizado judicialmente. Y ahí, de nuevo, como han hecho mis colegas acá, necesario distinguir aquella incautación material, en el cual entramos en el sinsentido de, para determinar si es o no privilegiado, tenemos que examinar el documento. Pero como decía Oscar, al examinar el documento, indirectamente nos estamos levantando el secreto y de esa manera determinar o no si efectivamente estaría amparado por el secreto. Ahora, la práctica es conservadora. Si hay algún indicio en el mismo equipo investigador respecto de la existencia de un documento que tiene esas características, no es producto de la incautación y por lo tanto nunca llega a ser parte de ello, ¿ya? En el caso de las incautaciones de, información digital, que por su volumen no puede ser analizada en el mismo sitio del suceso, lo que se hace precisamente es la búsqueda respecto, la que yo no indicaba, pero no respecto de la existencia del privilegio, sino que su relación con el caso. Y en la práctica, si es que producto de esas búsquedas surgiere alguna investigación, o algún antecedente, que pudiera estar amparado por el privilegio, de nuevo se excluiría de la investigación. Lo único que pienso que de alguna manera nos permite estar tranquilos relativamente en esta área es que en la Fiscalía contamos con divisiones separadas respecto de quienes investigan la conducta en relación a aquellos que es la área en la cual yo me desempeño, llevamos a juicio el caso. Nosotros tenemos acceso al caso una vez que la división de investigación ha terminado su labor y por lo tanto aquello que ellos decidieron excluir, ya sea por este motivo u otros, nunca está al alcance de lo que nosotros vamos a saber que va a llegar a juicio para efectos de defender nuestro caso. De esa manera hay un recuerdo que al menos quien litiga el caso en el tribunal nunca tuvo conocimiento de la existencia de este procedimiento y eso podría considerarse una garantía en ese ámbito.
Thank you, Victor. Tobias, in the EU, what happens if it is determined that information is not privileged?
So in case we think it's not privileged, then we have, if it's added on rate, we also have a sealed envelope procedure as mentioned here. And then we have a so-called hearing officer who is has a certain independence within DG Competition because he's related directly to our commissioner and not part of our normal administration. And his role is to really protect the rights of defense. So the party can ask that he opens the envelope and takes a look at it and then makes a recommendation to the administration. But the party has to agree. Otherwise, we would ask the party for more proof on it. And if we think it's not privileged, then we would issue a decision, which is also checked with our legal service, which is also separate. Checks and balances, a separate department. And this decision could then be challenged. So they can go to court, they can ask for interim relief. And we have a little bit the problem, as Mark said, even if they go for interim relief, it takes them, our courts, maybe 6 months to come up with something. So how do we avoid the abuse in there? If it's in an antitrust cartel proceeding, then if later the court finds that it was clearly not covered, then we can take that as an aggravating factor in the fines calculation. So we can increase the fines. So that takes it a little bit off. And in the merger perspective, we can stop the clock. If we think the document is so important and we need it and we have strong belief that it's not privileged, then we would stop the clock, meaning they could not close the transaction until the court decides, which also puts a certain pressure not to abuse that right.
Thank you, Tobias. And John, can you please tell us what happens in the CMA when the information is not considered as privileged?
If it's material that we already hold because we've taken it in a blue bag, for example, then we just keep the material. In theory, a party could go to court to get an order disputing whether it is or isn't privileged. That's never happened in practice. People tend to just accept the outcome of the process. If it's material that we have requested and hasn't been provided to us, then the party, assuming it's covered by the subject of our warrant or our request for information, the party will be under a legal obligation to provide us the material. And if they didn't, then we could fine them, or ultimately we could go to court to enforce the request. But again, that's not happened in practice, fortunately.
Thank you, John. Victor, in Chile, how is the information separated from that which is not subject to the privilege? And who may access such information?
Sí, como les mencionaba en la intervención anterior, precisamente, gracias. Un tema, digamos, de nuestras investigaciones es que es el mismo equipo investigador quien accede y quien decide qué tipo de información es amparada por el privilegio. Como señalé también, eso no pasa como información sensible o parte del proceso ante la litigación del caso. Hay un resguardo adicional, sí, que es importante tener en consideración. Si el equipo investigador determina que cualquier información de esta naturaleza está incluida dentro de las medidas efectuadas de incautación, tiene la obligación de devolver todo eso al interesado antes de terminar la investigación. Todo aquello que no pasa como evidencia al juicio es devuelto a los afectados en forma previa y de esa manera se garantiza que no tengan acceso terceros ni otras personas ni el mismo equipo de litigación a ese tipo de evidencia. Ahora, tomando en consideración lo que decía el magistrado Thorne en la exposición anterior, si es que eso, y es algo que tenemos que trabajar, si eso podría considerarse que de igual manera podría abrir algunas líneas investigativas al equipo de investigación respecto a las cuales no tenía antecedentes y por todo eso, digamos, incurrir en el tema de la doctrina del árbol envenenado es algo sobre lo cual tenemos que considerar esa posibilidad. No hemos tenido la experiencia ahora que se haya levantado porque, como te decía precisamente, somos bastante cautelosos en la naturaleza de la evidencia que utilizamos.
Thank you, Victor. Jonathan, what about Canada?
So Canada is essentially the same thing we've heard of separating documents. If the documents are found not to be solicitor-client privileged, going to the Competition Bureau. I think what's interesting is that Section 19 of the Competition Act really sets out a code as to how this could all happen in practice. It doesn't always happen exactly that way, but I read some of that to you before, basically that you have to put it in the custody of somebody else. And one of the possibilities is to put it in the custody of some agreed upon person. We were talking about before, an independent lawyer. And then it says that a judge of a superior court, etc., will determine whether the sitting in camera, whether the solicitor-client privilege is valid or not. But in practice, it rarely gets to the court. It's usually decided by the independent lawyer and the lawyer for the target. It also indicates if within 30 days, so you're doing a search and they say, no, that's solicitor-client privilege, it's placed in the custody of someone else. If within 30 days nothing happens, they haven't either come to an agreement or made an application to the court, it's then provided to the commissioner. In other words, you can't just wait around and hold things up.
Thank you, Jonathan, and thank you all for your answers. I'm sure everyone in the audience found the discussion interesting and enriching to the Mexican experience. I once more thank the speakers for traveling to Mexico and for their contributions that will allow an effective application of legal privilege in Mexico's jurisdiction. Gracias a todos por su atención y espero que sigan disfrutando del seminario.